have to constitute a larger bench of 7 judges and then stay Rabia's case, and then they will proceed. So today, I don't think they'll be able to reject the Rabia's case. They can only constitute. And once that 7 judges bench, constitution bench decides, then only the Rabia's case can be, set aside. And yes, obviously, the reference here would be to larger. And since there are other issues also involved, I think they all are interrelated. So, in my opinion, they may decide 1 or 2 issues or may entirely refer everything to the 7 judges bench.
Speaking to us, Swadesh Ratan Nigam, advocate Supreme Court, giving us his perspective as a crucial hearing there happening as we speak. Shinde camp against a larger bench, whereas the Thackeray faction, which is called for a larger bench in this case. The visuals there on your screens right now, live streaming from the Supreme Court. As we speak, now this is...
Justice Deepak Mishra, as the learned Chief Justices then were, and by Justice Madan B. Lokur. The opinions of Justice J.S. Kehar and Justice Deepak Mishra hold that the Speaker should desist from considering a petition for disqualification under the 10th schedule to the Constitution when a notice indicating an intent to remove him has been moved. This principle is formulated in the following observation in the decision of Justice J.S. Kehar, para 194. We hereby hold that it would be constitutionally impermissible for a Speaker to adjudicate upon the disqualifications petitions under the 10th schedule while a notice of resolution for his own removal from the office of Speaker is pending. A similar view has been expressed by Justice Deepak Mishra in the following extract from para 238. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of Article 179C, and the said interpretation serves a litmus test of sustained democracy founded on rule of law. And the founding fathers had so intended, and the constitutional value, trust, and morality unequivocally so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceeding under the 10th schedule of the Constitution after intention to remove him from his office is moved. However, Justice Madan B. Lokur, in the course of his judgment, held that, para 401, in the view that I have taken, I am of the opinion that the view expressed by my learned brothers relating to the power or propriety of the Speaker taking a decision on the 10th schedule of the Constitution with regard to the 14 members of the Legislative Assembly does not at all arise in these appeals. The issue of whether a reference to a bench of 7 judges should be made cannot be considered in the abstract, isolated or divorced from the facts of the case. Whether the above principle, which has been formulated in Nabam Rebia, has an impact upon the factual position in the present case needs deliberation. In the above backdrop, the issue whether a reference of the decision in Nabam Rebia to a larger bench is warranted would be determined together with the merits of the case. Consequently, the batch of cases is set down for hearing on merits on Tuesday, 21 February 2023 at 10:30 a.m.
Viewers, what's happening in the Supreme Court as we are speaking? First, I'll tell you there are all the people are already standing in the Supreme Court for this historic verdict. We can see senior advocate Mahesh Jethmalani, who appeared for the Shinde camp. Inside the courtroom, we see Tushar Mehta, Solicitor General of India, who presented and was present in there. We see Maninder Singh, who's also standing there. For the other side, that is the Uddhav Sena side, we can see Kapil Sibal and Dr. Abhishek Manu Singhvi, who are standing there. Now,